Danielle. The application to proceed without prepaying fees or cost approved, filed regarding parties' responsibility to notify the court of address changes, certificate of service that has yet to be completed, order on application to proceed without prepaying fees or costs that was filed and entered on August 28th. Then there was an order directing service by the U.S. Marshal filed August 28th, an order of reassignment disqualification on August 30th. The service documents received is still open. And just yesterday, filed and entered was a summons that was issued. I'm going to tell you what that means right now. So, a summons in a federal court case is a legal document issued by the court to notify a defendant, in this case, that being Danielle Robertson, a lawsuit, that a lawsuit has been filed against them. It serves as an official order requiring the defendant to appear in court and respond to the plaintiff's complaint. The summons provides important information about the case, such as the court information, the name of the court where the lawsuit is filed, the parties involved, including the names of the plaintiff or plaintiffs, the party filing the lawsuit, and the defendant, the party being sued. The case detail, a brief description of the case, including the claims or charges brought against the defendant. This is an important one. Time to respond. Let me just put this up right now while I'm reading. So at the top of it, it says summons in a civil action. Kimberly Smith is the plaintiff versus Danielle Robertson, with the civil action, the case number, and the honorable judge's name. Okay. All right. So there's more to this. There's more to this than meets the eye. And I'm going to talk about it because some of you have already posted comments. And when I say some of you, there might be people in the bushes, pro on one side or the other, okay, who think that this is an impossible undertaking. Okay. By that I mean that Danielle the summons within the time frame once it is served upon her. Okay. So it's already in motion. The U.S. Marshals will have their order to serve the complaint and the summons, the documents. And criminal cases, the summons must be served properly using a process server or law enforcement. In this case, it will be the U.S. Marshals. This is done to ensure that the defendant is formally notified. Okay. So here's a question that I had, and you might have the same question too. Well, what if the defendant, in this case, is Danielle? This is just one of many questions in no specific order. What if the defendant says on her YouTube channel or her social media platform that she will never be found and says that she's not going to show up? Can I provide the court with this further information? I, being a third party who has yet to file a lawsuit against Danielle Robertson, because I want to know. I want to ask that question. Before I answer that, let me just, do you have questions? And hang on for just a second. Let me just make sure I mute certain things in the background. I think that's a reasonable question to ask. That's a fair question to ask. But there are legal ramifications. So then, when researching this and looking into it, the short answer would be yes, that a person can provide the court with the video proof of the defendant's statement from her YouTube or social media channels as it is relevant to the case. Relevant to the case, all right? Especially if Danielle is actively avoiding the court's summons. Okay? I could say she, but I'm being specific. Or I can say it in general terms. Okay? This type of evidence I'm reading can be very important, and there's several reasons why. One, in establishing intent to evade. What if Kimmy Smith, who's filing this lawsuit, doesn't have any evidence to show that the defendant, Danielle, is not going to show up? She doesn't have any documentation, nothing, okay? Record, no evidence, but she's just saying she's not showing up. Well, the defendant's statement that she will never be found and that she's not going to show up, it demonstrates her intention to avoid the legal process. This could be used to show willful evasion of the summons and refusal to participate in legal proceedings. But there's more. Supporting a request for default judgment. Here's another reason why it might be important evidence, because it would go to support a request for default judgment. So then if the defendant fails to respond, let's say appear in court after being properly served with the summons, and you can provide evidence that she has explicitly stated her intent to avoid the case, you can request the court to enter a default judgment in your favor. It's a ruling made when one party, in this case, the defendant, does not fulfill their legal obligations to participate in the case. So this is why I'm asking these questions. Additionally, it's important because court procedures for evading defendants is a part of these cases. So in federal cases, if a defendant evades service or refuses to appear after being properly notified, the court may take action like issuing a bench warrant, that's in a criminal case, or imposing sanctions. For civil cases, the court may move forward with the case without the defendant's participation, potentially ruling in favor of the plaintiff by default. Okay. So then there's other questions. What if the third party, in this case, I'm a third party. Anyone else could be a third party who has also been harassed, abused, all kinds of adjectives that you could assign to it by this same person. So then what if a third party has also experienced this and has evidence to the same but hasn't filed yet? Can they use this evidence if it's the same party involved? I asked the question. The response was, if a third party has evidence of harassment, abuse, or whatever the case is by the same person, the defendant, but has not filed their own lawsuit yet, they may be able to use that evidence in their case under certain circumstances. However, whether the evidence can be admitted will depend on its relevance, the rules of evidence, and how it is introduced to the court. So there's some key considerations, like, is it relevant to your case? So for evidence to be admissible, it must be relevant to your claims. So for example, if the misconduct, abuse, harassment experience by the third party is similar to your situation, your being the plaintiff, and demonstrates a pattern of behavior by the defendant, it could support your case. There's also something called prior bad acts, okay? In both civil and criminal cases, evidence of a defendant's prior act or acts known as prior bad acts or pattern evidence can sometimes be admitted to show a pattern of behavior, intent, or motive. For example, if you're alleging abuse or harassment and the third party has similar evidence, it could bolster your claim that the defendant has a history of such behavior. However, courts are careful about admitting this type of evidence because they don't want it to unfairly prejudice the defendant. But then there are federal rules of evidence. It's called Rule 404B. This rule generally prohibits, listen up, using prior bad acts solely to show that someone has a propensity to commit such acts. However, it can be used to show intent, knowledge, motive, or absence of mistake, which may be relevant in your case. Third-party involvement. Let's think about that one. And then again, these are questions that I have been looking up. If a third party is willing to testify or submit their evidence, they could do so as a witness in your case. Under oath. Okay. Let me pause because that may already bring up other questions that people have. Daniel Robertson has affected multiple people. I'm yet one person, but I'm key. Here's why. I have evidence already on record to show a pattern of behavior of harassment and cyberbullying above and beyond over the course into documents. I have an attorney who has already represented me, has already responded to legal issues with my name and Daniel Robertson's name and same address. I already have a history with this individual. So Kimmy Smith wouldn't have to say, can I find someone? Is it possible? Who has facts, has documented proof, evidence, and a behavior and contacts and a history to show that this individual, Danielle Robertson, has said out of her own mouth how she is going to evade the law. I have multiple receipts where she has signed documents swearing that her legal name, not some pseudonym, but her legal name is Danielle Robertson. Not only did she sign the documents and swear to them, she even boasted on recordings that I have in her voice that she provided my lawyer fake information, that she provided YouTube, that she lied to YouTube. So she has admitted that she is a liar. I have that. Her saying that she is a liar. I have documents. Danielle Robertson on the document across my picture, where she has superimposed my face onto another nude body in a graphic sexual manner to defame me. I have multiple records where she has contacted the police. I've got records where she's contacted my family. I have records where she's posed and said threats against me. I have so much on Danielle, this Anon Robertson, just to give you an idea. And I have her entire collection of videos, every single one of her videos, every single one of her videos, all of her surviving nosy whole life, one through the end of it. I have all of her 2021, her 2022, her 2023, where she has gone on record to defame and say things and delete things. So, as a likely witness who would be willing to testify and be deposed under oath, if it could be admitted, then I have what I need, I think, that would show the courts that Danielle Robertson, if she tries to evade service, if she tries to evade the law, her intent has already been established. She has said, "Who's going to check me, boo? Nobody's going to find me." And that if they get close, I am going to disappear. I have it. Her own words are going to go against her. She's not even going to be able to say, "Well, that was the robot's voice," because I have her voice saying, in that case, if the robot's voice is heard on recordings, all she needs to do is deny that. I have her making that statement. I have a number of her statements. And no, I'm never going to show my own hand. But I want this person to be put on notice. And even though it's not my name on that lawsuit against her, I might be instrumental in the case. Let me go on. Let's see. Hang on, guys. You know what? Every time I talk about Danielle, it seems that I always get someone new that I've never seen as an avatar on one of my social media accounts outside of YouTube. It seems to always happen. You know, it's like maybe some people are sent to take notes just in case, Danielle can't listen for herself, because she's always watching and always listening to what I have to say when it comes to her, even though she says she's not interested. She's always interested. Especially when it comes to this. I'm going to read a few more of your comments, then I'm going to continue. Is this making sense so far? If it is, if you are enjoying the broadcast, just me talking about the subject, go ahead. You can hit the like. Okay. So now, before I get too far behind in reading some of these comments. Okay, so um, hmm, let me go up all the way to the top real quick. All right. Red Group says because it's a civil case, the defendant is stating an attorney can represent them without them being present. Represent you during a deposition if you've ever been deposed. So people are already trying to think their way out of it, trying to say, well, I'll hire an attorney and they're never going to get to me. It's going to be layers. Well, that attorney can be asked questions too, even if he speaks for his client. If he's an attorney, he's passed the bar, he's taken an oath, he has a license, a bar license, he can be looked up too. His credibility, her credibility. What cases has he represented or her represented? Records. So when it gets to that point, if it gets to that point, but that's a very good question and or statement. Comment. And that's right. You can use a chat GPT. I see Cheryl Lay says chat GPT said yes, a person can be deposed in court while using an alias, but certain legal protocols must be followed. You see, isn't it great to have technology and AI databases to ask questions? Yeah. Trust me, she has access to the same databases. And she has money to hire an attorney too. But remember what I've already talked about as a third party, if allowed. Danielle Robertson has a history of doing things to defraud. Danielle Robertson has a history, and this isn't defamation. I've got facts. This isn't slander. I'm not going to lie. I have receipts. I wouldn't jeopardize anything by making stuff up. Danielle Robertson on this platform has a long history of circumventing the truth for protecting her anonymity so that she can do bad things, very bad things. And now that there is a legal case against Danielle, that's record, Kimmy could also take that to YouTube and use it to subpoena records because it's a case now, it's a legal document. Cheryl Lay says, her identity is not the primary concern. What matters is that she should be terminated from YouTube for doxing. Many people could care less who Danielle Robertson is. But in order to pursue a legal avenue and to get justice, and to pursue justice, this is part of the pursuit. She needs to be held accountable, not a pseudonym, not an anonymous person. The person who boasts, who gonna check me, boo? She needs to be checked. Yes, she needs to be held accountable. Okay. Let me go on. See if there's anything more. Okay. Any other questions that you have? I've asked a number of questions. Like even to the point of when and how and why to file, even against an anonymous party. Yeah. So when people ask me, well, you could file a Jane Doe. If you're being defamed, harassed, abused by someone online who is using an anonymous username or pseudonym like Danielle Robertson, the answer is yeah, you can file a lawsuit against them until you uncover their true identity. You see, it's got to get to the true identity eventually. One instance is, yeah, she could be sued as an unknown for, intellectual property violations, copyright infringements, those kinds of things, where the infringer's identity is initially concealed, because in copyright claims, it can be initially concealed or is. But you can do it with the intent to discover their identity, and it would certainly be my intent. So then the main reason for filing a lawsuit against an anonymous defendant such as Danielle, it would be to compel disclosure of that person's identity. Mm-hmm. And then once the lawsuit would be filed, then it can be used in the court to process, to subpoena the internet service providers such as YouTube and the others I'll just say this. And again, I have an attorney. I have spoken about such things. Okay? Ask how difficult it is to get Google to respond, even when there's legal. However, it can be done. So then a third party like myself, getting that information, assisting, could help to reveal the defendant's identity. It's going to be challenging. Who would just say that it wouldn't be if they don't know who you're dealing with? We're dealing with someone whose intent it is to remain anonymous and go around any method she can to either responding and keep in mind, Danielle, an anonymous person, says and does things. She files out forms illegally. She will respond with more layers of lies if she thinks that she can get away with it, to stall, to delay. But it's legal. This is a legal document. There's a summons. All right? It's a case. And a U.S. Marshal, because of the way Kimmy filed and her circumstances, has allowed her to do it with, I'll just say, minimum cost and to get the benefit of having law enforcement, a The fire has begun to burn. And as the fire catches and gets bigger, as long as it's not doused out and the flame gets hotter, as an analogy, a fire can spread quickly. This individual on YouTube, this isn't a one-off. This is an individual who has a record of abuse. No, I have a document where she has been on other social media, on X, on Twitter, abusing me. And I have the document from Twitter that says in the words, abuse, Danielle Robertson. You see her name with that to describe her from a social media account in association with Danielle Robertson. Abuse against me. I have such records. She has a long and deep history of abuse, as being a fraud. So do you expect a fraud not to behave in a fraudulent manner? This is what we're dealing with. This is what the court will be dealing with. Do you think I expect, or Kimmy should expect? Now, I can't tell her what to expect, but I can tell you what I expect. How about I speak for myself? Do you think I expect Danielle Robertson to be willing to comply to a legal summons? My expectation, the bar is already low. So if she performs above the bar, it's going to be shocking to me. So the bar for Danielle to comply, it's so low. My expectations for her dealing in the truth is not. It's almost like a minus. That's what we're dealing with. I have statements from her, how she's going to get around the truth. I have statements and videos of her admission to lies, to legal, not just to some other YouTuber, but lying to cover things up, admitting to impersonating, and then going on to say her reason for it, and then going on to say because she'll get away with it. That goes to her motive. That goes to her intent. That goes to her character. That goes to who she is. It's already a plan that's in motion, in place. She's already spoken of layers just for this time. She's already said it's chess, not checkers, and that she always wins. You see, if it were not for these recordings being saved, she's even said in some of her recordings, you've got to have receipts. She says no one's going to believe you unless you have receipts. She was boasting that in a video, talking to me as I was downloading the video. As she laughed and mocked. And as I remained silent for a long time, she didn't know. 2021, what I might suspect as she began to move in such a way. She doesn't know everything. She thinks she's smarter than everyone. She has a record, a history of lying. These items in this history for this case, these documents, as they come in, will be filed. They will each get a document number, 1 through whenever it's closed. It's a record. As Danielle likes to say, it's a paper trail. No, this isn't a paper trail, Danielle. This is a real legal document. This is real, Danielle Robertson. This isn't a paper trail. So if I've called it a paper trail, no, it's a lawsuit. It's a legal document with a case number. And as documents and dates get put into this and updated, I'm going to be watching it. I know Kimmy is going to be watching it. And there are other interested parties, while they may not say so, because there are some people just waiting on the sidelines, waiting. She never thinks that there's a time that she's going to be caught. That's why she's so cocky and arrogant. That's why she will boast and not hide it. But I bet you she's been hiding some things because she's afraid they're going to come out. How much you want to bet she's been hiding some things that she doesn't want people to find out about? Yeah. Listen carefully. Danielle, a summons has been filed in federal court. And when it's served, you have 21 days that you've got to respond. I can't say everything I know. Yeah. It's about pulling back the layers, guys. We're going to end it there. Thanks for watching. Until next time, I'm Teddy. Good night.